Poole X. Rel. Elliott v. Textron, U.S. District Court for the District of Maryland. Grovey, U.S. Magistrate Judge. Introduction. This is a product liability case in which the plaintiff, Ryan W. Poole, has sued Textron, Inc. for alleged defects in a golf cart which resulted in serious injuries to him. Before the court is plaintiff's request for attorney's fees and other expenses related to the 3 substantive discovery motions and their sanctions. The motion for sanctions raising 6 instances of discovery abuse, the motion to compel production of documents, and the motion to determine sufficiency of answers and objections to requests for admissions. Request for attorney's fees and other expenses related to 3 substantive discovery motions and other sanctions. It's kind of the cause of action. Lost my pen. Here we go. Textron acknowledges this court's authority to assess sanctions to punish discovery abuses under Rule 37, Rule 26G, and the inherent authority of the court. However, Textron argues that an award of fees is inappropriate for several reasons. Chiefly, Textron argues that its collection and investigative efforts to comply with the court's May 20, 1999 order were both extensive and expensive, costing Textron $23,260 in attorney's fees and expenses. That sanction is, in Textron's view, sufficient. Alternatively, Textron argues that plaintiff's request for expenses, including fees in the amount of $50,346.89, is grossly excessive under governing law. Specifically, Textron objects to the hourly rate charged by the plaintiff's counsel is not in line with those prevailing in the community for similar services by lawyers of reasonably comparable skill, experience, and reputation. I don't know if these are counterclaims or just arguments. Part 2, after the introduction, is titled Governing Law and Entitlement to Sanctions and Expenses, including Attorney's Fees. As Textron acknowledged, this court has authority to redress discovery misconduct under the federal rules as well as under its inherent powers, and can impose a range of sanctions from awards of expenses against both a party and its counsel to an entry of a default judgment. The sanction, of course, depends on the nature of the discovery abuse. The court's inherent authority is not displaced or limited by the sanctioning scheme of the federal rules. Citing Chambers versus NASCO in 1991, the Supreme Court has cautioned restraint in the exercise of the inherent powers because of their very potency. Again, Chambers. And because inherent powers are shielded from direct democratic controls. Roadway Express Inc. v. Piper of 1980. Accordingly, whether default judgment or some lesser punitive sanction, such as an award of attorney's fees, is imposed under the inherent powers, courts require evidence of misconduct, usually characterized as contumacious, fraudulent, or bad faith, with some courts requiring that the misconduct be shown by clear and convincing evidence. As will be more fully discussed below, this court finds the sanctioning scheme of Rules 37 and 26 of the Federal Rules of Civil Procedure sufficient to redress the violations here without exercise of the inherent powers. As to plaintiffs' motions to compel and to test the sufficiency of the answers and objections to the request for information, Federal Rules Civil Procedure 37 governs both the entitlement to expenses and the amount of such expense. If such motion is granted, the rule provides in pertinent part, the court shall require the party or deponent whose conduct necessitated the motion, or the party or attorney advising such conduct of both of them, to pay to the moving party the reasonable expenses incurred in making the motion, including attorney's fees. Is this the rule? I feel like that's the rule. Is that the rule? Yeah. Unless the court finds that the motion was filed without the movants first making good faith effort to obtain the disclosure or discovery without court action, or that the opposing party's non-disclosure response or objection was substantially justified, or that other circumstances make an award of expenses unjust. Whereas here the motion is granted in part and denied in part, the court shall apportion the reasonable expenses incurred in relation to the motion among the parties and persons in a just manner. The court has determined there was no substantial justification for Textron's non-disclosure responses and objections, and that there were no circumstances that made an award of expenses unjust. Is this like, which court? Is this a holding? Or is this the lower court? What court did that? I don't know. Similarly, Rule 26G3 provides in pertinent part that if without substantial justification the certification is made in violation of the rule, the court, upon motion or upon its own initiative, shall impose upon the person who made the certification the party on whose behalf the disclosure request, response, or objection is made, or both, an appropriate sanction which may include an order to pay the amount of reasonable expenses incurred because of the violation, including a reasonable attorney's fee. By its language, Rule 26G3 does not limit a court to the award of expenses only, but gives the court latitude to fashion an appropriate sanction. In addition to an award of expenses, nevertheless, an award of attorney's fees appear to be the sanction most commonly imposed in reported decisions. The court has determined that while counsel for Textron signed the various discovery responses, counsel has not conducted the requisite reasonable inquiry, and that the quality of the responses suggested an appropriate improper purpose, specifically to cause unnecessary delay or needless cost of litigation. Accordingly, there was no substantial justification for the certifications in violation of the rule. Thus, in the absence of certain findings which the court does not make here, the rules direct the imposition of a sanction. So the facts are saying counsel for Textron signed the various discovery responses. That's a material fact. However, counsel had not conducted the requisite reasonable inquiry, and that the quality of responses suggested an improper purpose. I think this is alleged facts. Anyhow, it could be facts by the fact finder. Although this is the district court hearing this, so I don't know where the facts are coming from. Part 3 of this opinion is titled Plaintiff's Motion for Determination of Sufficiency of Answers and Objections to Plaintiff's Request for Admissions. So I get the idea that the defendant is bringing the cause of action against the plaintiff. I mean, is motioning for sanctions. The plaintiff's request for attorney's fees and other expenses related to 3 substantive discovery motions and other sanctions. The motion for sanctions raising 6. Before the court is plaintiff's request for attorney's fees. But the defendant is saying that the plaintiff costs too much. I don't know. Regarding the plaintiff's motion for determination of the sufficiency of Textron's answers and objections to plaintiff's requests for admissions, the court finds under Rule 37 in conjunction with Rule 36 that Textron's responses or objections were not substantially justified. To the contrary, with one exception, the responses and objections appeared crafted to sabotage the legitimate use of request for admissions. Under the plain language of the rule, a party must either lodge an objection or an answer to a request, but cannot do both. Pursuant to the requirements of Rule 36A, the answering party that objects to a request for admissions does so at its own peril. That is, Rule 36A mandates that a matter is admitted unless a written answer or objection is served on the requesting party. Rule 36 also states in detail the requirements for denials, objections, partial admissions, and qualified answers. Failure to adhere to the plain language of this statute requires that the fact in question be admitted. Rule 36 expressly permits a party to qualify an answer, but only when good faith requires. In almost every response, Textron impermissibly lodged both an objection and an answer. Moreover, when Textron filed an answer, its complexity undermined the efficacy of the rule by crediting disingenuous, hair-splitting distinctions whose unarticulated goal is unfairly to burden the opposing party. Accordingly, this court believes the defendant's responses and objections lack substantial justification, as the court granted relief as to 12 of the 13 contested requests, or 92% of the requests. Court grants that percentage of the attorney time and expenses reasonably related to this motion. All right, so it sounds like these are holdings. Part 4, plaintiff's motion for sanctions. In this motion for sanctions filed pursuant to Rule 37 and the inherent powers of the court, plaintiff charged that defendant Textron engaged in improper discovery tactics, which were willful, inexcusable, and not in good faith, and asked for a finding of liability or alternatively certain relief tailored to each of the alleged instances of discovery abuse. The court found that many of plaintiff's complaints of discovery abuse were meritorious and ordered considerable relief in terms of further investigation and production of discovery responses. Part A, Textron's lack of diligence in providing key requested information. 1. Textron's response to plaintiff's request for protection. So, under A, the conduct this court has found sanctionable violates Rule 37 and, in some instances, Rule 26G as well. Particularly egregious was Textron's lack of diligence in providing key requested information, such as prior litigation involving the golf car model or testing whether, in its response to requests for production of documents or its identification of designees for the corporation's deposition on the same subjects. Textron's response to plaintiff's request for production. So request for production of documents is one of their problems. So that's the one we're going to go into first. But then there's also its identification of designees for the corporation's deposition. So for part 1, this court has concluded, as plaintiff states, that Textron did not perform an even minimally adequate search for documents prior to plaintiff's motion for sanctions. At the court's request, Textron described its efforts to locate documents and information requested by plaintiff. Review of Textron's 7-page single-spaced letter showed half-hearted, scattershot inquiries prior to the court-ordered investigation and inquiry efforts, oftentimes only reacting to leads that plaintiff's counsel. That letter did not dispel the court's previously held impression that Textron's initial inquiry in response to written discovery requests, as well as Rule 30b-6, corporate designation, started and largely, if not entirely, stopped with an inquiry to Mr. Gerald W. Powell, a Textron reliability engineer and EasyGo's designee in golf car litigation since 1981, and with a review of the official corporate records of Textron. It appears that Textron did not even contact its own employees in other corporate departments, such as the manager of Textron's commercial media relations, to respond to the document requests or requests attached to the corporate designee notice. However, another and perhaps greater proof of the inadequacy of the initial inquiry was the productivity of the additional efforts mandated by the court, which confirmed that the demands of the rules and case law on the level of inquiry and the broad definition of control under Rule 34. First, the sheer volume of documents provided after plaintiff's motions and court order produced in response to discovery demands under the rules demonstrates the inadequacy of Textron's initial efforts. Textron initially produced a single page in response to plaintiff's document request. After plaintiffs served motions to compel and filed one such motion with the court, which was granted, Textron produced a total of 470 pages of documents. After plaintiff filed his motion for sanctions, Textron produced 20 videotapes and more than 2,900 additional pages of documents that are responsive to the discovery request. Given the results of court-mandated efforts, it is clear that these documents were in the control of Textron and that a reasonable search would have located them. Second, a review of Textron's responses. So this is facts. These are material relevant facts of conduct that they want to discipline. Second, a review of Textron's responses to certain of plaintiff's specific discovery requests likewise demonstrates a lack of an adequate inquiry. For example, a plaintiff had propounded a request for all advertisements and promotional materials that concern or refer to a couple different models for years from 1978 through 1990, request number 23. In response, Textron produced a single brochure. When plaintiff moved to compel further production on the basis that it was inconceivable that Textron had only used a single brochure to advertise and promote its golf cars, Textron responded curiously that an inspection of plaintiff's own exhibits demonstrates that Textron has already produced all such materials concerning the discontinued model line. I do want to go back to like the first page of this case where the defendant was complaining about attorney's fees and expenses and the amount of $23,000 is a material fact. And what they're saying is the requested discovery cost $50,000. Anyhow, those are material facts too, but I don't know if they were meritorious, found to be met with merit by the court. After the court-ordered investigation, Textron produced 229 pages of advertising and promotional materials, including photos of the golf cars on grassy slopes, much like on which the accident occurred here. Include 26G of the Federal Rules of Procedure defines the duty of counsel in responding to discovery requests. That is, counsel must make a reasonable effort to assure that the client has provided all the information and documents responsive to the discovery demand. In this case, it is clear that defendant's counsel did not make a reasonable effort under the rule to assure that its client had complied fully with plaintiff's discovery request and obtained all documents within possession, custody, and control. Clear, right? Which clear and convincing is the standard of proof in some jurisdictions. Part 6, an award of reasonable attorney's fees and costs is the appropriate sanction, right before Section 7, the conclusion. So, in an attempt to ward off any sanction, Textron represents to this court that its counsel spent at least 154 hours, 0.6 hours on document collection and investigation efforts to comply with the court's May 22nd, 1999 order at a cost to Textron of $23,260, and argues that it has now cured at considerable expense all deficiency found by the court, and that an award of sanctions could, under the circumstances, be unjust. Because they've been cured. Such an interpretation of the rules would encourage sharp practices and dilatory responses to legitimate discovery demands. If the only sanction for failing to comply with the discovery rules is having to comply with the discovery rules, if you are caught, the diligent are punished and the less than diligent rewarded. Indeed, Rule itself defeats such an interpretation, as it provides in Elliott that the court shall award the moving party fees if the discovery is provided by ruling or simply after the motion is filed. This is clearly not a situation where justice should be tempered by mercy, given the comparable resources that the plaintiff and defendant and the inescapable conclusion that Textron stonewalling on discovery played on that disparity. Sanctions are to be awarded against parties or persons unjustifiably resisting discovery. According to advisory committee notes, so they're trying to look to legislative intent here. I think they could just look at the statute and possibly agree with the defendant, because these things are supposed to be settled before motioning. Yeah, these things are supposed to be discussed between the parties before you motion the court. So had they been properly discussed, no motion would have been required. And that's why I think Textron has a legitimate period of argument that they have the ability to cure before it reaches this point. But let's read on, because I don't know precisely anything about what we previously referred to as meet and confer. Any activities in that arena to meet and confer before we reach the motion to compel and motion for sanctions. So they're just saying that the advisory committee, as a source of legislative intent, wants to say that Rule 37 sanctions must be applied diligently, both to penalize those whose conduct may be deemed to warrant such a sanction and to deter those who might be tempted to such conduct in the absence of such deterrent. NHL versus Metropolitan Hockey Club. Likewise, Rule 26G is designed to curb discovery abuse by explicitly encouraging imposition of sanctions. Another advisory committee note to that rule, which I think is not what was intended, based on just reading the law. So anyway, however, in the absence of a bad faith finding, the court is not justified in awarding sanctions beyond the relief afforded by Rule 37 and Rule 26G, and certainly not entry of default judgment as plaintiff repeatedly requested. Moreover, with the exception of the court's finding of a Rule 26G violation for which imposition was an appropriate sanction, is permitted in addition or in lieu of an award. The individual discovery abuses represent violations of 37A, and Textron did not violate. Any order of this to the court is thus limited to an award of the reasonable expenses incurred in making the motion, including attorney's fees. Yeah, because that is a remedy under the rule. And I want to say remedy. It does say remedy here in that sentence, but it might be a sanction authorized under the rule. However, the fact that the court did not find bad faith does not minimize the wrong-headedness of the conduct of Textron and its counsel or suggest lenience in the imposition of the rule delineated sanctions. The court recognizes there is an unquantifiable real prejudice to plaintiff in the motions practice that Textron's conduct necessitated, and the legislation disadvantages of the delayed and staged receipt of discovery that was its consequence. For example, depositions are taken without the belief or benefit of later received discovery. That later received discovery might have eliminated the whole areas of inquiry or suggest entirely different questioning at deposition. In that situation, a lawyer is faced with the dilemma of whether to spend the time and expense to seek another deposition session or to make do or belatedly received information may impact the expert's opinion, requiring additional analysis and a further report and even a further deposition. So the analysis is that litigation is very much disadvantaged, and here's the examples. Textron argues that its costly compliance with the court's May 20 order is punishment enough. The court disagrees. A significant sanction award is crucial to vindicate the important principles of fair play in the largely private world of civil discovery. In complex litigation such as this, cases are shaped, if not won or lost, in the discovery phase. The integrity of the discovery process rests on the faithfulness of parties and counsel to the rules, both in spirit and letter. And that's where I diverge. Okay. Conclusion, part 7. For all these reasons, the court imposes a monetary sanction of $37,000 jointly and severally against Andrew Gendron of Goodell, DeVries, Leach, and Gray, and Textron, Inc. Mr. Thomas M. Goss is jointly and severally liable with Mr. Gendron and Textron for $4,000 of that $37,000, which are the fees and costs associated with the motion to determine the sufficiency of answers and objections to requests for admission. I guess that's what the attorney is responsible for. Ow, doing.